Trump slams Jack Smith for continuing to litigate the January 6th case. We know that the case is on appeal. Judge Chutkan said that the litigation at the lower level was stayed. So why is Jack Smith continuing to file discovery requests and notices and dump all this material on Trump's desk when he's not even in this courtroom anymore? He's in the Court of Appeals. Well, Jack says, I'm allowed to do this, and I'm going to continue to do this because, as we expect is going to happen, the D.C. Circuit Court of Appeals is going to come back down and say Trump does not have presidential immunity. The case can go back on track. And when that does, Jack Smith is going to say, we're ready to go. This trial date can come back to March 4th, Judge Chutkan. So let's go. Well, this is Trump's final response to this whole back and forth. Trump submitted a motion saying, hold him in contempt. This case is stayed. Jack Smith replied, said, I'm not following anything you say. This is Judge Chutkan's courtroom. I'm going to have everything I want granted anyways. This is Trump's final word. The reply. Trump submits the reply saying Jack Smith should be held in contempt and there should be an order to show cause in place. And an order to show cause is like being called to the principal's office. Not good. So here Trump says, look, all right, Jack Smith, illegitimate, illegally appointed, office totally not even real. All right, Jack, they say, dear Judge Chutkan, having been caught, busted, knowingly, repeatedly, and blatantly violating this court's stay order, yours, Judge Chutkan, the so-called special counsel and his assistants here in the prosecutors, lowercase, nice, love it, offer no excuse. Instead, they engage in a failed attempt to rewrite the record, claiming that Judge Chutkan's stay order prohibits only those actions that require a response from Trump. Remember, they said, well, we can file whatever we want. Trump doesn't have to respond to anything, and so therefore he's not burdened. And you say, hello, first of all, we're not going to let you just file stuff on a docket and just be totally removed from the situation. Just file whatever you want. We'll come take a look at it when you're done. No, that's our docket too. And so us just having to monitor the docket is effort. Okay, if you file some nonsense like this motion in limine that they submitted, obviously Trump's team needs to know about it. What if they just filed a motion just to hold a trial in absentia and Donald Trump is guilty as charged? And Chutkan says, great, perfect. No, the defense needs to be there to monitor that. So everything that we're witnessing here from Jack Smith is requiring action. And there's another concept. When you file motions, you have to ask the other side, do you agree with this? Do you oppose? Do you object? What's your position on this? Do you agree or do you object? We need a continuance. We need this motion. Do you object to them? So when they have to ask the other side about that, that is a burden. So Jack Smith wants to just say, well, I'm building, my house on my side of the road. It has nothing to do with yours. No, Jack, you're not. It's not only yours. It is the shared docket. So here's what they say. Now, as the prosecutors are fully aware, the stay order says nothing of the sort. It doesn't just limit Trump, limit them from doing stuff that requires a response. It's not what the order said at all. The order from Chutkan expressly prohibits, here in bold, any further proceedings. Jack, can you read it? One that impose additional burdens of litigation, like having to check the docket to see what type of insane things you're filing on President Trump or anything that moves this case towards trial. Any. Now, the prosecutor's filing attempt to achieve both of those unlawful goals. And so accordingly, Jack Smith should be ordered to show cause as to why he should not be held in contempt of this court. Judge, you said don't do it. He did it. Then we filed an objection to it and he said, we're going to continue to do it. They continue. Trump's defense rights. Now, the prosecutors, Jack Smith, they argue that President Trump is, quote, not obligated to review. Well, he doesn't have to read it. We can just submit it and it can just sit in his inbox. If he wants to read it, that's his problem. Or that he doesn't have to respond to the filing and the discovery, and therefore there is no burden. They say this is false, obviously. Now, as an initial matter, President Trump must examine all documents the prosecutors file in this case, obviously, when they are filed to determine whether and how they should respond. Now, this is because both the prosecutors and the court have taken the unsettled position that the court may address and resolve certain issues notwithstanding the stay order. Chutkan said, well, I still have a jurisdiction over Trump's gag, for example. Okay, so the court has retained the ability to control Trump's speech. She said, well, that doesn't impact litigation. That's just a management of the case. And so she bifurcated that. But in other words, they could file something about that would put it within the defense's purview, saying the court should not assume at this juncture that no issue can arise that is not involved in the appeal. Now, the court, said Chutkan, does not understand the required stay of further proceedings to divest it of jurisdiction to enforce the measures, which is the gag order, that we've already imposed to safeguard, they say, the integrity of the proceedings. Weird, because all Jack Smith's prosecutors leak information to the media and file garbage in their motions that the media runs with. So it's safeguarding the integrity relative to Trump. He can't talk, but everyone else can. Now, President Trump also cannot know whether a filing relates in whole or in part to an issue that the prosecution says is not involved in the appeal without reviewing the filing filing. Because remember, the appeal stays the stuff that is related to the appealable issue. In this case, it's presidential immunity, which is kind of a big issue, which means it spreads this massive umbrella over the whole case. But presidential immunity doesn't really relate to judicial administration of a case. So in other words, no matter how the Court of Appeals rules on presidential immunity, Chutkan is still going to be able to control decorum of her courtroom and Trump's speech via the gag order. So she retains some of that. Now, therefore, when something goes into that docket, they've got to keep their eye on it. So he must perform that review on receipt. And we don't trust the government to say, well, we're filing this and it only has nothing to do with the appeal. So they say, obviously, if we have to review Jack's filings, clearly that's unquestionably a burdensome task. And the stay order says no. Here, a filing violates the stay order. Where it does, a President Trump must preserve his rights by clarifying. When they submit something, Trump has to say, we're not accepting it and we're not substantively responding to the filing. And that is a burden on us, a burden the prosecutors have already wrongly forced on Trump. And they've required this multiple times. Every time he's got to respond to this, he has to say, we're not reading it. We're not reading it. We're not reading it. That's a burden. Now, second, and they can't read it because they're in the Court of Appeals. Now, second, as the prosecutors are fully aware, Jack Smith and his deranged thugs, and no doubt intend, their filing of politically motivated and charged invective, like the recently filed motion in limine, it induces substantial negative media coverage against Trump. It burdens him both personally by falsely impugning his character and professionally by undermining his leading campaign for the 2024 election. And worse, the Jack Smith so-called prosecutors, they also publicize their untruthful arguments. They know it's not true, knowing that any press coverage will be entirely one-sided without Trump's substantive responses. And just as the stay order shields Trump from the burdens of trial and discovery, it also protects him from other burdens of litigation as well. Now, although Jack Smith and the prosecutors generically deny a political motivation, yeah, right, such words are empty. The prosecutors' filings, including the motions in limine that we read here, closely mirror the Biden campaign's dishonest talking points, a fact that the prosecutors do not and cannot deny. The timing of the prosecutors' filings, likewise, also cannot be explained by the posture of this case. Why are they filing now? Oh, the case is stayed, so it's a political hatchet job. Instead, they synchronize with the Biden campaign's recent media blitz. They're out saying, Trump is Adolf. Trump's going to end democracy. Got a bunch of clips in the next couple segments, which relies on the same discredited appeals to emotion that pervade their filings anyways. Here, Dave Smith wrote about this in The Guardian, says, fired up Biden shows gloves are off on January 6th anniversary speech. Joe Biden, right, going around to everyone. Trump's going to wreck democracy as his party's throwing people off ballots. Now, this time it's personal, said Joe. On Friday, Joe Biden tore into his predecessor Trump as never before. He brimmed with anger, with disdain, and with contempt. And once more, they note from ABC News, they say, weird. Anonymous sources, quote, sources familiar with what Smith's team has learned during its probe, they've resumed their deliberate and unlawful effort to damage Trump through leaks of false and defamatory information. All these anonymous sources, it's weird. They all go right to the Times, the Post, ABC News. They've got DMs to the media. It's not a coincidence, says Trump's team, that the Biden campaign, the prosecutors, and, quote, the sources close to the prosecutors are all attempting to simultaneously flood the airwaves with matching anti-Trump rhetoric during the stay. And prosecutors' filings also impose a prohibited burden on Trump by wrongly and very publicly accusing him of committing a crime when the appellate courts should determine that he acted lawfully under immunity principles. Now, these false accusations are irreparably harmful to Trump and his reputation, and they represent defamation per se in any other context. Now, for the same reason, Trump cannot ignore the practical implications of their unlawful actions, but must instead take reasonable steps to defend his reputation, especially considering the political nature today. Now, given this, it is unsurprising that the prosecutors, Jack Smith and them, they cannot cite a single case that has allowed continued motion and discovery practice during a stay. Is there one, Jack? And these people, by the way, prosecutors are supposed to do justice. They get badges and all sorts of stuff, and they're not, in this case, particularly, doing the opposite of justice. Now, finally, the prosecutor's assertion that Trump is not legally obligated to review the discovery is meaningless. The defendant is never obligated to review the discovery. They can throw it right in the toilet, and some defendants do. Like, oh, whatever, I'm guilty, I don't care. Take the plea. I don't even read it. Now, moreover, and regardless, the prosecutors obviously argued for an unconstitutionally rapid trial based on the idea that Trump somehow should have identified and reviewed millions of publicly available documents before he was even indicted, despite his obvious lack of obligation to do so. And remember, the timing of this case is nuts. I mean, it was like 9 months from indictment to trial, and there were 14 million pages of documents documents, which is also insane because remember, Walmart versus Visa had like 7 million pages and that took like 7 years to litigate. Huge, massive numbers. But they say Trump can handle like double the documents in 9 months. No problem. All of his attorneys can read like ChatGPT, just reading everything. So although such documents represented only a small fraction of the total discovery, which is many millions of non-public documents as well, the court accepted this argument for speedy trial. Chutkan said, well, we already kind of knew about January 6th, and we already kind of knew a lot of these things, and Trump's got a lot of money and a lot of lawyers, and so they should have been looking into it before he was even charged. And you go, that's new. Not heard that one before. But Judge Chutkan apparently is, the constitutional whisperer, and she found it out of somewhere. Now, denying President Trump his rights to due process and adequate time to prepare for a trial, she said this. You've known this time was coming, she said, probably, giddy. Mr. Trump's counsel has known this was coming for some time, and I'm sure any able, diligent, and zealous defense counsel would not have been sitting on their hands waiting for an indictment. So you should have already been reviewing the discovery from years ago. Crazy. Now, the prosecutors make no secret that they're going to attempt the same maneuver here, and they're going to defeat the purpose of the stay order and unlawfully impose enormous burdens on Trump. So do you see the foreshadowing here? Chutkan already said you can have trial in March because you should be doing your due diligence. Even though you never were officially charged with a crime, you should hire defense lawyers to defend you and review millions of pages of documents that you're not even sure where the prosecution is going, and then they prosecute you. They say that for Trump. Now, he might actually have the resources to do that, but he's got no obligation to do that. And the fact that he could have done that doesn't mean that she gets to suddenly deprive him of his due process rights because maybe she had a different perspective on how this should have been handled at the outset. Anyways, it's crazy. So she just makes it up. But you see, the argument is she's going to do it again. Well, Trump, even though you were on appeal, you should have been reading Jack's motion. You should have been reading these new disclosures. And he's going to say, but I didn't. And she's going to come, well, you should have been. So they have to make their record. We are not reading anything. Take your stupid discovery and shove it. So here they say, look, the prosecution's actions are now attempting to move this case towards trial, saying the prosecutors bizarrely and inconsistently argue that their filings did not even move this case towards trial. Well, that's weird. But simultaneously, they claim that these filings are necessary to ensure the prompt resolution of the case. That's prosecutor logic right there. Okay, let's see if they can rectify this. They say that production was necessary to ensure that trial proceeds promptly if and when the mandate returns. I know I'm just a lowly defense attorney, but if it doesn't move the case towards trial, because if it did, it would be prohibited, but it helped the prompt resolution of this case, kind of sounds like a trial, because Trump's not taking a plea deal unless they're going to dismiss this, which doesn't look like that's happening. So the prosecutor's embrace of Orwellian double talk aside, this argument defeats itself. If the filings and productions help prepare the case for trial and they're necessary for a prompt resolution, well, then by definition, they move the case towards trial. Hello. It's a trial, a plea deal, or a dismissal. Indeed, the prosecutors present no reason for the filings other than the unlawful reason, which is the desire to accelerate the trial schedule. Now, their stated intention is illogical. It violates your order, Judge Chutkan, and it has no basis in law. The actions at issue, filing motions and producing additional discovery, they're archetypical examples of proceedings that advance criminal cases towards trial, obviously. Yeah, what you do. They're normal proceedings. So much so that the court used those exact proceedings to illustrate the stay order prohibitions. Now, although the prosecutors, Jack, they attempt to distinguish the court's example by pointing to the word requiring and misses the point. Requiring additional discovery or briefing would violate the stay order because those activities literally advance the case towards trial. And so here is the same thing. Prosecutors, their motions, and their discovery are literal admitted attempts to advance the case, and they violate the order regardless of whether Trump is required to immediately respond or not. Now, any remaining arguments are meritless from the government. They claim that they do not understand the order to prohibit either party from voluntarily complying with the order. But nothing in the stay order suggests this is optional. It explicitly and plainly stays any further proceedings that impose additional burdens of litigations on the defendant. Chutkan's words, not ours. This is logical because, as explained above, the prosecutor's, quote, voluntary efforts to advance the case, it does impose burdens on Trump, and the stay order protects us against that. Otherwise, it would literally be meaningless. Now, next, they argue that the stay order also excludes discovery. They say any further proceedings, they say this is baseless. Any further proceedings means any further proceedings. It's clear. Now, to the extent that the prosecutors had any genuine confusion, which might be possible because they're idiots, regarding the meaning of the word any, I don't know, they are not that bright. Let's see if they understand what the word any means. Hopefully they explain it to them. They should have conferred in good faith with Trump's counsel, and they should have asked for clarification, but they didn't. Instead of seeking clarification about what the word any means, they, which is a pretty common word, this is a fact that well-seasoned prosecutors should be able to interpret. Any claim confusion now is just ex post after the fact cover for their intentional misconduct. Now, finally, the prosecutors claim that they informed the court and the defendant of their unlawful plans, and they said they would do, because the court did not forbid them from doing it. Well, they didn't say we couldn't. They say no. Yes, they did, actually. The prosecutors are wrong. The plain language of the stay says, like, actually, it forbids your actions. Do not submit stuff unless it meets the exceptions. Any reasonable person, that's the problem. We're talking about prosecutors. Any reasonable person would understand this to mean the court had denied their request. And again, at the very least, the prosecutors should have, but did not, request a clarification before violating the very stay order. And when they did that, they unlawfully burdened President Trump. Now, wrapping this up, John Lauro submits, he says, now the prosecutors claim, Your Honor, Chutkan, quote, that they would never intentionally violate an order of the court. But they have repeatedly done just that, without a shred of support and without even asking for clarification. And now, Jack Smith and his deranged thugs, they now brazenly promise to continue their misconduct unless the court intervenes to enforce the plain language of the stay. Saying, Chutkan, you and this court should reject Jack Smith's blatant effort to undermine your authority and order Jack to show cause. Bring his butt in here to explain why they should not be held in contempt. Signed by your friend Todd Blanche and John Lauro on behalf of Donald Trump. And so, a nice motion. Now, of course, this is the final word. Jack Smith already submitted his response. So we'll see what Judge Chutkan does. Do you think that she is going to rule against Jack? Do you think he's going to be ordered to show cause? I don't. She's going to say, well, let me issue a clarifying order so that Jack Smith and his confused, deranged, illegitimate prosecutors know what they can and cannot do. And it's probably going to be the end of it. And we'll see what Jack does in response to that. Now, I could be wrong. Chutkan could come out and say, well, no, that is all allowed. Enjoy, Trump. And we'll see what he does in response to that. Maybe even appeal that order. But we'll be here continuing to cover Trump's defense, obviously calling out Jack Smith for their illegal, unconstitutional filings, saying Jack Smith should be held to account. We're going to be here continuing to cover the Trump trials everywhere they are, my friends. So thank you for joining us as we do. And also thanks for checking out robertgovea.com. If you want to get the PDF that we went through, the red lines, if you want to sign up for our daily newsletter and get all the stories summarized and sent to your email inbox so that you can forward them to everyone you've ever met, Robert Govea is the place to do that. We'll look forward to seeing you there and back here on the next one.